No exhibit 23 because we withdrew it.
Correct. And we do have 34 in there because it's part of the record, just as you instructed, Your Honor.
Great, thank you.
I will get that over to you now, Ms. Minnie.
And then the other thing I was going to address is, I know y'all said you don't anticipate having much rebuttal, if any, but I was going to give each side, I think, 20 minutes for rebuttal if you decide you need some rebuttal, just so we finish today. So we're going to continue with Mr. Hassan's case in chief when we get back on the record. But I'm going to limit the rebuttal to 20 minutes each, and then I'll give each side a closing argument, because I have some questions that I may ask if it doesn't get covered in the remainder of this case. Just a couple, but I've got a couple of questions as well. So let's go ahead and get on the record. Minnie, whenever you're ready, let me know.
I'm ready.
The court's back on the record in cause number 20 DCV 275644, the Nelson matter. We're going to resume the temporary orders hearing. When we left off, we were on the direct examination of an adverse witness by Mr. Haston on Mr. Nelson. And Mr. Haston, you may proceed with your questioning.
Thank you, Judge. I'm having a little bit of a hard time remembering where I left off, so I hope I don't recover any territory. I know I had to go through and admit each exhibit the long way. I believe I was just starting to ask questions about them. So that's where I'm going to begin today, is just a flag to the court and the parties. Mr. Nelson, I'm going to refer you to, well, I believe, I just want to make sure, last time we were before the court, you agreed that you had been withholding zero on your pay stubs. Is that right?
That's incorrect.
Okay. How many dependents do you claim on your pay stubs?
11 exemptions.
And when did you start claiming 11 exemptions?
I have been. So if you'll look at Exhibit 27, if we take that exhibit up on the screen, I want to point out in the claim section on the top right, that's if I claim any additional money, so like $100 or $500 a paycheck. But if you look in the top page under tax status, it shows federal married. There's a number right next to that showing 11. That's the number of exemptions.
Okay, and how many actual dependents do you have?
If you include myself, Miss Nelson, Slayton, Alexis, and the two children in this case, Aniston and Bryston, that would be 6.
So why claim 11?
We paid in for taxes in 2020, a little less than $1,000, and I was claiming 11 on there just due to the move.
So you believe that by claiming 11, you'll still come out just about fine at the end of the year and not actually owe any money for 2020?
That was correct at the time. I have since switched that and changed that. And yes, today I'm claiming 0 due to the divorce situation. So in 2021, it will be 0.
So for 2021, you're claiming 0 exemptions, not even including yourself, correct?
That's correct due to
objection, non-responsive after that's correct.
Sustained.
Which means that's less net income available to you to pay bills of the community estate each month, correct?
That's correct. That's correct.
All right, I'm going to move on to Exhibit R28. This is R28. This document was produced by you in evidence, and I'm going to ask you if you can identify this document.
That's a financial statement.
Of what?
A Vanguard account that I own.
Is this your 401k?
Yes, that's correct.
And so the sub accounts are all part of the things that make up your 401k, correct?
Those are mutual funds and associated with that. Correct.
All right. And you have one loan out against your 401k?
That's correct.
And what amount? What do you still owe?
$45,000.
Okay, so besides that, you don't owe any money to the 401k.
No,
You could take further loans from it if the court were to so instruct, correct?
that's correct.
And the current balance of your 401k, how much is that?
It looks like 707,000 on that document.
Yeah, I'm asking you currently.
I don't know.
Do you not check your accounts frequently, sir?
No, I don't.
When was the last time you checked your balance on your 401k?
When I pulled this document.
Okay, so knowing that we were going to be talking about balances of accounts and values of accounts, as of the last hearing, I was asking you all about the balances of accounts and whether you looked at stuff. You didn't bother to look at your 401k balance between now and then.
No, Craig, I did not.
So you have no way of knowing whether your account balance is higher or lower.
I would imagine that it's higher due to what the stock market's done over the past 3 months.
How hard would it be for you to log into your computer right now and find out what the balance of that account is?
I can do that if you would like me to. I can tell you that the state has plenty of money to pay for the attorney fees.
Okay. So I'm not asking you for an exact number, but would it be fair that it's somewhere over $800,000 right now?
I would say that it's over $700,000. That's accurate.
But would you mind checking for us and testifying to the court based on what you find out from the internet? While he's looking, Judge, is my image as grainy on your end as it is on my end?
No, it looks good to me. Everybody's looks good to me.
Okay, because everybody looks great to me, but mine just on my end looks like I pixelated from 1985.
After removing $42,000 yesterday to pay for attorney fees, it's $756,000.
Okay, so you're telling the court you withdrew how much yesterday?
$42,000, which I will only get a check for $31,300 after taxes are paid out of that.
And did you cash it out or take a loan?
I already have a loan, so that you can't take another loan against your 401k. You can only have one loan against your 401k.
Have you double checked that you can't have a second loan?
Yes, I know that you can take $50,000 out.
Wouldn't it have made more sense to liquidate another account that wouldn't cost you taxes plus a 10% penalty?
We've liquidated everything that I can at this point, besides what's owned by Miss Nelson, which is $16,500 in a brokerage account, plus $148,000 in a traditional IRA.
But you're in control of those accounts, aren't you?
They're solely under her social security number.
But you would have to give her password and login in order for her to be able to get those, wouldn't she?
No, sir. She can call Vanguard. She can reset a username. She can reset a password. It's solely under her social security number. She also has a Midland Memorial Hospital 403B that has about $15,000 in it that she has access to.
And when did you, do you have the password and the login information for her accounts?
I did until she changed it.
Oh, so you're telling us that she's changed the accounts, then sign in on her own accounts.
I haven't been able to sign in on that account since October. And all you have to do, because it's under her social security number, is
Objection non-responsive.
Same.
I'm going to point you to Respondents Exhibit number 29, the computer share stock. Do you know the current balance of the computer share stock, or does it still exist?
It's roughly 26,000.
Okay, and you have 237.79 shares. I'm sorry, you have 129 shares, don't you?
That's separate property.
I'm not asking you whether it's separate or community, sir. I'm asking you how many shares you have that are available to be liquidated.
I can't read your screen.
Okay. Pull that up for you. As of September 20th, can you read us that number right there?
It looks like it's 129 shares, not 267.
No, I corrected myself and said 129 shares. And then that would be multiplied by whatever the current value of Microsoft stock is, correct? To get today's value.
That's correct.
And that one has not been liquidated.
No,
All right, I'm going to show you folio investing. Does that exhibit 30s? Does that still exist?
no.
What happened to folio investing?
Been expended to pay for attorney's fees.
And I see on here that on this statement, it says you withdrew $16,493 as of between November 1st and November 30th of 2020. What happened to those funds?
That was paid for attorney's fees for immediately after, I believe that was after our second emergency motion.
Okay, and since then, you've cashed out the rest of it to pay attorney's fees. Is that what your testimony is?
Yes.
And showing you R31, this is your, well, tell us what this is. This is your restricted stock, isn't it? I'm sorry, I didn't catch that.
Yes, that's correct.
Okay, and this top section up here is the restricted stock where the restrictions have lapsed and they're available to you to cash in, correct?
That's correct.
And you have a total of 228 available, I guess it's Phillips shares of stock?
That's correct.
And according to this, as of whatever date that was, January 4th of 2021, the market value was $15,866, correct?
That's correct.
And have you cashed those in?
No.
Okay, so those are still available. Let's look at 32. This one's Respondents Exhibit 32, and the only document you provided us regarding this Roth IRA was a transaction history. It doesn't tell us anything about the current balance of this account. So can you tell us what the current balance is approximately of your Vanguard Roth IRA?
Approximately $60,000.
60?
Yes.
And you have not cashed out your Roth IRA yet, correct?
No.
And that's virtually tax-free to the extent there's no capital gains. Am I right?
Yes, per how much I put in there. I've only put 12,000 in there ever.
And you know capital gains aren't going to be more than 20% maximum, right?
So you will pay a tax on that.
Right. Capital gains tax of no more than 20%, 15 to 20%, right?
Pay an income tax as well.
Yeah, you pay capital gains tax on gains. You don't pay income tax.
Whatever I withdraw from the Roth IRA will be counted as income against the estate.
But instead of cashing that out, you opted to take out money from your 401k, which would also add on a 10% penalty. Is that true?
That's accurate.
And lastly, this is a statement from your Chase credit card, correct?
That's correct.
And I may have asked you about this, so please forgive me if I did, but what is the total of, not the total available balance, but what is the highest credit limit you could have on this card? $39,000?
29,500.
Has it always been 29,500?
Yes.
Okay, you haven't asked it for it to be reduced?
No.
Have you asked for it to be increased?
No.
And have you been taking the money from the accounts that you withdrew money from to pay down this credit card?
Yes.
And this is the place where both you and your wife were putting your attorney's fees charges, correct?
That's correct.
And it's your testimony that the community estate has plenty of funds to pay both attorney's fees throughout the remainder of this case, true?
Teresa has enough funds. Yes.
Non-responsive objection.
I didn't hear his response, but it sounded non-responsive. Sustain. What was your response, sir?
Yes, between Teresa and I, we have enough funds.
And do you have any objection to both of you continuing to put your attorney's fees on this credit card and then pay it with funds from the community estate?
Yes.
Why is that?
As we look at Teresa's account, she has two accounts that are solely tied to her Social Security number. One at Vanguard, which has an after-tax mutual fund account worth approximately $16,000, and a traditional IRA worth approximately $132,000. She also has an account with Diversified Investments, which is associated with a 403B from Midland Memorial Hospital worth approximately $15,000. In addition, Teresa also has a Nursing World MasterCard with a credit limit of $27,500, which would be enough for incurring attorney fees for you on a monthly basis. We also heard Ms. Nelson state she is making approximately $37,500 per year at her job. And if the estate is responsible for paying attorney fees, I feel the court would be doing an injustice to the estate by having myself responsible for all attorney fees, as it would increase the tax burden of the estate and ultimately decrease the overall value of the estate. If your attorney fees exceed—
Objection, non-responsive and narrative at this point, Judge.
Sustain.
All right. I'll pass the witness.
Mr.
Oh, I'm
Adams?
sorry. Excuse me. I'm sorry. I have one more question. Sorry, one more question.
All right, you may.
Mr. Nelson, did you get a bonus here this year?
Yes,
How much was that bonus?
$17,000.
I'm sorry, how much?
$17,000.
$17,000?
Yes.
Where did that money go?
Pay attorney's fees.
And why have you not, when did you get that payment?
March 1st.
But you haven't supplemented your discovery to give us that pay stub, have you?
I have not been requested to supplement.
Objection, non-responsive.
Sustain.
No.
Pass witness.
Mr. Adams?
Thank you, Your Honor.
Can we stop the screen share?
Yes, sir.
Bo, what if anything is not accurately reflected in respondents R26 through 33?
So as I discussed previously,
Judge, I'm going to object to that being an overbroad question.
Overall, you may answer that, sir.
So we previously heard Mr. Hassan state that we are taking zero exemptions. So pointing out in the claim section on the top right, we look underneath that, we are taking 11 exemptions there. We also heard Mr. Hassan ask Ms. Nelson if we received a tax refund in 2020. The answer is no, we actually paid back to the IRS slightly under $1,000. Also, if you look at Exhibit 27, underneath that statement, there was $148,405 of earned income as of February 2020. That's quite a large sum. So if I could direct the court's attention to the bottom right of that document, you will notice there are several large dollar value line items, including several for moving expenses, relocation, and one for a stock grant offset, making up a significant amount of that earned income for the year. 2020 was not a normal year for Teresa and I. As far as income, you heard us talk about relocating a full share, and the company has a very lucrative relocation plan. I would also like to direct the court's attention to Exhibit 30, which is the account for folio investing, which we just discussed. That account no longer exists as it previously had. That has
Objection, that's been asked and answered. He's already said that no longer exists.
Sustained. Next question, Mr. Adams.
Bo, how did your wife pay for the lawyer she hired to represent her in Amarillo?
So Teresa utilized $3,446 in Amarillo out of our Pantex Federal Credit Union checking account.
When your wife receives a bill from Mr. Haston, how has she paid for those bills in the past?
Through my Chase Visa credit card.
Do you know how much in total the community has paid Mr. Haston for legal services?
Approximately $55,000.
Bo, the last time you received a bill from my office, do you remember what my hourly rate was?
$250 an hour.
Based on the documents you reviewed in this case, what is Mr. Haston's hourly rate?
$475 an hour. 90% more than what yours is.
Objection, non-responsive.
Sustained.
Bo, how would you like for attorney's fees to be paid in this case moving forward?
As I stated previously, Teresa has two accounts that are solely tied to her Social Security number. She has sufficient funds of $165,000. If Mr. Haston's fees exceed that $165,000, I will gladly take the remainder of the burden. But to preserve the community estate and to reduce the tax burden on myself, I would prefer that the court allow Teresa Nelson to pay her own attorney fees moving forward.
Bo, would you be more likely to settle this case if your children's primary residence were ordered to be in Fort Bend County?
Objection calls for speculation.
Overruled.
Yeah.
Yes, I would.
Pass the witness, Your Honor.
Ms. Kern? You're muted.
I'm sorry, I was muted. Judge, I have no further questions for this case.
Mr. Haston?
No further questions, Your Honor.
Mr. Haston, you may call your next witness.
Let's see. I'd like to briefly call Teresa Nelson back to the stand.
Okay, you may proceed.
Thank you, Your Honor. Ms. Nelson, did you just hear Mr. Nelson's testimony about the funds that you have access to?
Yes.
Okay. This is something you've told me that you don't have any access to. He's kept you from having access to funds. Is that true or not true?
Yes.
Okay, and explain to the court in what way you've been prohibited from having access to funds and accounts.
I have asked him on numerous occasions to provide me with the password. He provided me with the username, and then every time I would ask him to provide me with the code so that I could get into the account, he refused to give it to me. He said he was busy watching a football game, or he was busy cooking out, or he was busy hanging out by the pool and didn't have time to sit by his phone and wait for me to provide him with the code. And so I was never able to get it. And so just recently, I had to send a letter to Vanguard requesting access.
And when was
and
that?
I have yet to. It was in the last couple of weeks. They sent me a form that I had to fill out and return.
And do they send out email or paper statements, Vanguard?
Paper statements
And where do they go?
to Bo's residence.
Does Bo ever send them on to you?
He's given me mail once.
Has he ever sent you the Vanguard statements since in 2020?
He gave me,
Answer yes or no, please.
yes,
Okay, how many times?
once,
When was that?
about 2 to 3 weeks ago, I believe. I can't remember exactly.
So that was the first time in over a year you had seen anything about your own finances.
Correct.
Okay, and when we're talking about Vanguard, what account is this?
I believe it's my Roth IRA.
As we sit here right now, do you know the balance of your Roth IRA?
All
Yes
I
or
have
no?
is no, probably not. No.
Okay, do you have any way to find out?
The Mint app was last updated about 4 months ago. And so that's the last I've been able to see what the balance is.
Based on your knowledge of what you've seen, what do you think the balance of that account is?
Approximately 125,000, I believe.
Okay. But as we sit here today, you cannot actually access that money because you have not had access to it up to this point.
Correct.
Is this the same Roth IRA that your husband's been managing throughout the marriage?
Yes.
Is this a rollover from a prior retirement benefit?
Yes.
And was it a retirement benefit that you had prior to your marriage?
Yes.
So he wants you to spend money that you had before your marriage to pay your attorney's fees, is what I'm hearing.
Correct.
And then do you have a 403B?
I have a small amount from the year that I worked in Midland.
Do you happen to know the balance of that?
I do not.
Who gets the statements on that?
I don't know. I assume it goes to the address in Fulshire.
And were you married at the time that you earned that money?
Yes.
I don't recall what your husband said the balance was on that account. And besides the Vanguard and the 403B, do you have access to, do you have any other funds, he said, that are connected to your Social Security account that you know of?
Not that I'm aware of, no.
And your husband is, up to this point, up until just very recently, been the one in control of all the community funds and finances, correct?
That is correct.
He's been the one making all the decisions on what accounts to cash out and what to pay in attorney's fees.
That is correct.
And he's the one that threatened you that he would essentially destroy this estate if you fought him on this divorce case.
That is correct.
That's what's happening right now, right?
That is correct.
And do you remember reading anything anywhere saying that you're not allowed to hire any lawyer, that anything keeping you from hiring the lawyer of your choice?
No, sir.
And it was your choice to hire me and my firm to represent you in this matter, wasn't it?
Yes, sir.
Do you believe that $475 an hour and then the hourly rates of my staff are fair and reasonable considering our expertise and background and the
Yes.
complexity of this case?
Yes, sir.
Based on the fact that your testimony that your Roth IRA was from a pre-marriage asset, are you asking the court to go to what we know to be community funds, such as the 401k of your husband, to pay attorney's fees in this case?
Yes.
And based on what you owe currently and what you anticipate you'll owe, you're asking the court for approximately $70,000 either to be paid all at once or in some stage of payments.
Yes.
Not the witness.
Mr. Adams?
Mrs. Nelson, you said earlier that, I'm sorry, let me start this way. When did you first ask Bo for access to the Vanguard account?
I don't have a date.
Do you know about how long ago it was?
Well, since I haven't had access for 4 months, I would assume it was probably approximately 4 months ago.
So approximately 4 months ago, you asked Bo for access to the Vanguard account.
Yes.
Testified earlier that you recently requested access to the Vanguard account, correct?
Correct.
Why did it take you 4 months to request access?
I just have had a lot going on.
Objection sidebar.
Pass the witness, Your Honor.
No further questions. I'm sorry. We left out Ms. Kern. Sorry, Judge.
Ms. Kern, any questions of this witness?
I have no questions, Judge.
Mr. Haston, any redirect?
None, Your Honor.
Mr. Haston, you may call your next witness.
Judge, I'd call myself at this time.
All right, test.
Thank you, Your Honor. Judge, I'd first of all refer the court to Exhibit 24, which is my engagement letter in this matter, which sets out the retainer fee and the hourly rates for myself and for my staff. I then submitted into evidence R25. I'm sorry, R25 is our engagement letter. R24 is my shorthand rendition of my testimony as to my qualifications. I don't want to spend any time reading that to the court, but my hourly rate is $475 an hour, and I've been board certified since 1999. I've been licensed, I've been certified as a mediator since 1999. I've tried hundreds and hundreds of cases in my career. I'm familiar with what is a reasonable and necessary fee with a person with my background and experience. I know that other lawyers of my background, experience, and abilities are making north of what I'm being paid an hour, but I believe that that's fair and reasonable under the facts and circumstances of this case. Currently, I want to testify to the court that our work in progress is $30,748, and that's just for the month of March. That's all the preparation we've had to do to make this hearing happen, and all the time we spent being in this hearing. And I'll let the judge, after having heard all the evidence in this, determine whether that was reasonable and necessary based on all the evidence you've heard, Your Honor. However, I do have $9,345 in my trust account. My client recently was able to pay a little bit on that credit card that we were talking about. So my net WIP as of prior to this hearing today was $21,403. Judge, I anticipate about another 50 hours of my time in this case if it goes to trial, about 30 hours for my paralegal, Tanya Jansky, and about another 40 to 50 hours of my associate, Corey Miller. Their hourly fees are set out in my documentation. And I believe that these fees are going to be reasonable and necessary. The concerns I have for the amount of expense we're still going to have is, number one, to get where we are today, we've been through 2 full days of mediation. We've been through multiple settings of different iterations of this case, of this hearing, none of which has to do with you or Judge Heppard, but has to do with various issues. I'm not going to blame anybody, but it has caused us to prepare and re-prepare and then have to, again, reaccumulate the information. We have an agreement for an amicus attorney who is very needed in this case, but that adds another element of communication and time involved. We have got an agreement to do a custody evaluation in this case, which is going to cost the community state money. But in doing that, it's also going to cost more time and effort on my part, my staff's part, in communicating with the doctor, providing them the information they need, having conversations or meetings with this doctor, and possibly having to take their deposition if we do have a trial in this case. To my knowledge, and David, correct me if I'm wrong, nobody has asked for a jury trial in this case. Is that right?
No objection from me.
Okay. Nobody's asked for a jury trial in this case, Judge, but if somebody were to ask for a jury trial, which is not going to be us, I anticipate the prices would probably triple. So I anticipate that we will have to most likely order a copy of this transcript if we cannot settle this case within the next few weeks, because from what we've seen so far, Mr. Nelson likes litigation and he likes having hearings and he wants to pursue these issues. And we believe that we're probably going to have to take his deposition to get further information. In addition to that, Judge, we both sides have done discovery in the case. We still have a discovery deficiency letter we have to write, which is going to take quite a bit of time because we do it right. In the discovery we received, we didn't receive a response to each and every one of our production requests. What we received was see Exhibit A to all of our requests if there wasn't an objection. And what Exhibit A is approximately 3,000 documents, none of which are in any order whatsoever, not chronological, not by document, not by subject. My staff had to go.
Objection, Your Honor, to relevance at this point.
Overruled.
So my staff had to take an enormous amount of time to go through all of those documents and do the job that should have been done in producing them to us in the first place and producing them in a manner in response that was responsive to our individual production requests. That took a ton of time and work. And when the time comes, when we produce all of our billing for trial, everybody will see how much time was involved in that. And I'm concerned that we're going to continue having problems with supplementation. Discovery, as you know, is one of the most expensive parts in some cases, and I think that's going to be one of the biggest problems in this case. I don't know whether Ms. Kern will have discovery or not to issue in this case, but if she does, that will be additional work to respond to. And we'll be happy to do that. So I believe that with all of this, I don't know if they will continue to have an expert witness besides the custody evaluator that we have in the case. But I'm probably I'm very much on the shy side of my projected fees and for the remainder of the case. But with hopes that we will settle it, I'm estimating that between now and trial, fees will be in the department of $40,000 to $70,000. But what we're asking the court today for is, my client said $70,000, but I forgot to tell her about the trust. So what we're really asking for is $40,000 going forward, plus the amount in WIP of $21,403, which is a total of $61,403. And we're asking the court to make it come out of, and I know everything's community until proven otherwise, but you did hear testimony that was uncontroverted by my client that these particular funds that they're alluding to in her Roth IRA were earned from employment prior to marriage. So where there is definite community property available, I would ask the judge order Mr. Nelson to liquidate and pay attorney's fees from that. With that, I'll pass myself.
Mr. Adams?
Mr. Aston, just a few questions. You mentioned earlier that your rate was $4.75 an hour. Can you tell us what Ms. Miller's rate is?
I believe hers is, I need to double check that. I believe it's $2.50 an hour.
And do you happen to know what Ms. Jansky?
Yeah, it's $1.25 per hour.
Sorry, I was doing some math. So on Monday, March 8th, when we had our very first hearing and appearance, you, Ms. Miller, Ms. Jansky all appeared that day. Were the Nelsons being charged $1,250 an hour for that by your office?
Yes, sir. On that day they were.
Okay. Do you know how much work in total you billed, Ms. Nelson, in this case?
If you can give me 1 second, I can flip over to that screen.
Thank you.
Including through the end of the day yesterday, $78,200, which is inclusive of the WIP that I was just speaking about.
And have any of the bills that you sent Ms. Nelson gone unpaid?
No, sir, they haven't.
Okay. Mr. Haston, would you just remind me one more time, because I thought I've heard different numbers. How much exactly is Ms. Nelson asking for today in interim fees?
$61,403.
Okay. I think you alluded to this, but isn't it true the likelihood that this case will settle for final orders is going to be greatly affected by the judge's ruling on temporary orders?
I think you said that, and I hope that's true.
You don't believe that's the case?
I don't know. I don't know, Mr. Adams. I really, truly hope that his ruling will lead to a settlement of this case.
You did mention earlier about a discovery deficiency. You haven't reached out to my office in any way about any deficiencies in our discovery, correct?
Not yet. No, we haven't. We've been working on it.
Okay. Nothing further, Your Honor.
Ms. Kern?
Judge, I have no questions on Mr. Haston.
Can you redirect Mr. Haston?
None, Your Honor. We rest.
All right, Mr. Adams, at this time, if you'd like to give any rebuttal witnesses, you may call them.
We rest, Your Honor.
I'm sorry. You know what? I forgot to ask Ms. Kern. I'm sorry to leave you out, Ms. Kern. Ms. Kern, before I go to Mr. Adams, are there any witnesses that you'd like to call in your case in chief?
I have tons and tons of witnesses to call, Judge. I have no other witnesses.
I couldn't mute you fast enough. Mr. Adams, you still rest?
I do, Your Honor.
All right. I'm going to give each side a closing, and I'm not going to limit your closings. Y'all just keep it y'all are all good lawyers and just understand we've got about an hour left today. So I don't need more than like 15, 20 minutes, I wouldn't think, of an argument. But each side's going to be able to give me a closing argument and ask the court what kind of requested relief you want. I would say, though, I do have a couple of questions, and I'm going to open the witnesses back up to all three lawyers after my questions. But I have a couple of questions. First, I'll start with Ms. Nelson. Ma'am, if you would please unmute for me. Have you done any research into any costs associated with, in the event the court were to award you the right to remain in Randall County, and I'm not saying I'm doing that, but in the event the court were to do that, have you looked at what the cost would be associated with Mr. Nelson to get a hotel room there in Randall County to exercise visitation? Because you said you thought he could spend the weekend in Amarillo to avoid the kids spending so much time in the car. So have you had a chance to do that? And if you have, what is the cost?
I have not, but I think that he could likely get a hotel room between $50 and $80 a night, I assume.
And as far as airfare flights from Amarillo to Houston and Amarillo, you said that there's at least one per day. Do you have any idea what the cost of that air travel is?
I believe we provided that. I'm trying to think how much it was. I believe it was around $400, but I could be mistaken.
Okay. Any questions of this witness after my questions, Mr. Adams?
No, Your Honor.
Mr. Haston?
None, Your Honor.
Ms. Kern?
Okay.
Mr. Nelson, you mentioned that your wife's retirement account, what was the value that you said, the most recent value that you're aware of is in her retirement account?
Total between the three accounts. So there's about
Objection non-responsive.
Yeah, I'm not asking about the Roth IRA. I'm familiar with the Roth IRA, but the retirement account from her work during the marriage relationship.
no. Thanks for the clarification, Your Honor. I believe about $14,500 to $15,000.
All right, and Mr. Nelson, in the event that Ms. Randall were to stay in Randall County, pickup and drop off you had been doing in Weatherford or Burleson County, cities. And you heard the testimony that she said that's costing or causing your daughter to have to leave school early. Do you have any proposals for pickup and drop off that would alleviate that concern in the event that she were to live in Randall County?
Yeah, I think the 1 hour delay. So right now she's bringing the kids to the house. We heard her testify to if she could leave 1 hour later, 10 a.m. That would allow her to be counted present and still be here by 7 p.m.
So you would, if you had your preference and she were living in Randall County, then the pickup and drop off would take place where?
So I think that she would still bring the kids to me, and then we would meet on Sunday in Burleson.
Have you done any research into what the cost would be to fly to Amarillo to exercise visitation or a hotel room in Amarillo, Mr. Nelson?
Well, the last time that when we did get a hotel room in January for Aniston's birthday, it was $129 after taxes. I think it was $129.12 actually. And the flight was $466.
Okay, any questions of this witness, Mr. Adams?
No, Your Honor.
Mr. Hassan,
None, Judge.
Ms. Kern?
And Your Honor.
Okay, let's go ahead and do closing arguments. Mr. Adams, you may proceed.
Your Honor, I hate to be this attorney, but if I promise to be brief, could we have a restroom break before I get started?
We may. Yeah, let's do that. We'll take an 8-minute break. We'll start back at 4 o'clock. We're on recess till 4 o'clock.
Thank you, Your Honor.
Okay, we're going to go ahead and get started. Mr. Adams, you may give your closing at this time.
Thank you, Your Honor. What's in the best interest of Aniston and Bryston Nelson is for their primary residence to be in Fort Bend County, Texas, with both of their parents. I'd like to discuss 4 different things with the court today. First, the public policy. I know I don't need to remind the court, but the Texas Family Code in section 153.001 says the public policy of this state is to assure that children will have frequent and continuing contact with parents who have shown the ability to act in the best interest of the child. The best way to ensure that Bo Nelson has frequent and continuing contact with his children, Aniston and Bryston Nelson, is for the children's primary residence to be in Fort Bend County, period. If the court is wondering, does Bo Nelson act in the best interest of his children? Yes. Yes, he does. Mrs. Nelson testified earlier that joint managing conservatorship is in the best interest of these children, that Bo should be consulted and involved in all the decisions regarding the children. She testified that Bo loves his children and his children love him. And most importantly, Mrs. Nelson testified that it was in her children's best interest to have a close and continuing relationship with their dad. Second thing I'd like to talk about is equity, or what's equitable. One reason bringing Aniston and Bryston Nelson back to Fort Bend County is the equitable thing to do is because Bo and Teresa Nelson have had a toxic and unhealthy relationship from the beginning. But this is the last place that they both chose to live as a married couple. It's in Fort Bend County. We heard Mrs. Nelson admit to that in the recording, respondents R14. She said, "You've done you since day one," referring to Bo looking out for himself. She also said, "From the day you met me, you gave me zero respect." We saw Mrs. Nelson say that same in the letter that she wrote Bo before they were married, where she broke up with him, even though she still stated she would love him forever because he was carrying on with other women. We heard Mrs. Nelson testify that she had assaulted Bo in the past, that she had drawn blood, and that on at least one occasion, the police were called where she and her young children were removed from the situation. I am not arguing that Teresa Nelson or any woman or any person for that matter ever deserves to be treated poorly by their spouse or their partner. But what I am arguing is that the evidence that we've been presented with shows that both these people made choices to continue to stay in a relationship, that they both sought counseling for their own issues and to preserve their marriage, and that they're both responsible for why we're here today. The second reason bringing Aniston and Bryston Nelson back to Fort Bend County is the equitable thing to do is because Teresa Nelson lied to her husband throughout the summer of 2020 so she could establish residence in Randall County, then file for divorce and stay in Amarillo. We saw P12. It was a text message from August of 2019 where Mrs. Nelson tells her husband regarding to move to Houston. And it hit me. It's not me who needs to make this decision, and it's not Slayton who needs to make this decision. It's you, as the man of the house, the one God chose to make the best decision for our family to make. We will support your decision because I know it will be made with all of us in mind. I know for the first time that you will lead our family to where we need to be right here and right now. I'm not sure what changed for Mrs. Nelson after she wrote that in August of 2019, but she testified that after sending that message, she realized moving to Houston or to Fulshire was not in her family's best interest and no longer supported that decision. Yet, she signed the papers on their new 3,900 square foot house in Fulshire. Yet, she assisted in the planning and selection of materials for their outdoor kitchen. Yet she uprooted her son Slayton, took him away from his biological dad, and moved him to Houston. Mrs. Nelson wants us to believe that she sent that message, P12, and took the actions that I just described, and yet she did not agree with or support their move to Fulshire at the time that it happened. Mrs. Nelson's own timeline and testimony from this hearing claims she and Bo separated on May 3rd, 2020. Yet in P15, she emailed their insurance provider seeking marriage counselors on May 19th, 2020. Specifically in that email, Mrs. Nelson, 16 days after she was to have established new residence in Amarillo, told the insurance company she no longer lived in Amarillo and would need marriage counselors located near Fulshire, Texas. We saw P20. That was a picture of Mr. and Mrs. Nelson out on a fishing boat on July 25th, 2020. When I asked Mrs. Nelson what she was doing in Florida with her husband over 2 months after they separated and she established a new residence in Amarillo, she said that she and Bo were still working on their marriage. We read P21. That was the handwritten note Mrs. Nelson lovingly left for her husband after their Florida trip, where she justifies her return to Amarillo. She says, Bo, thank you for being so understanding about my dad needing me. I appreciate that. Thank you for working so hard to provide for the family. I hope that we can both continue to work on healing. Love, Teresa. A week or so after that Florida trip, on August 2nd, 2020, we saw P22. Those were text messages between the parties where both parties state they agreed to separate, not so that they could divorce, not so that they could start living independent lives, but so they could reconcile. In that message, Mrs. Nelson denies that she would enroll their children in Amarillo schools. Less than 1 week after Mrs. Nelson denied that she was divorcing her husband and would enroll their children in Amarillo schools, she filed for divorce in Randall County, claiming she had been a resident of Randall County since May 3rd and enrolled Aniston in Amarillo schools on August 7th. We saw P24. That's the order dismissing Mrs. Nelson's Randall County divorce. That order specifically said the court finds that petitioner Teresa Lynn Nelson was not a resident of Randall County at the time she filed this suit for divorce. So Mrs. Nelson filed for divorce, claiming she was a Randall County resident. There was a hearing on the issue, and the court found that she was not a resident of Randall County when she filed for divorce on August 5th, 2020. The third thing I'd like to talk about today is the best interest of the children. Opposing counsel has pointed out several times during the course of this hearing that we've admitted a lot of pictures into evidence. And that is true. We have. Not a single picture was objected to by opposing counsel or by the opposing party, which means that every single picture tells us one thing. Bo Nelson was an involved stepdad and dad to all of his children. We saw pictures. We know Bo Nelson makes his kids breakfast on the weekends. Even Mrs. Nelson couldn't deny that. We know that Bo Nelson takes his kids fishing, and he's the kind of dad where they actually catch fish. Bo Nelson takes his family kayaking. He takes them to the beach. He went to Dad's Day for his stepdaughter, Alexis, at Oklahoma State University. All those pictures add up to one undisputable fact. Bo Nelson is an involved dad. And any decision that leaves these children in Randall County or in Amarillo is going to come at the expense of him being involved in their lives. Let's talk about abuse for 1 second. Now, I could run down for the court the evidence we've heard in this case regarding anger, outbursts, poor behavior. I think it's undisputable at the very least that both parties have engaged in some of that behavior. I don't need to go through every piece of evidence and draw fine distinctions about whose behavior might be worse. The bottom line in this case is that Mrs. Nelson has testified that joint managing conservatorship is in the best interest of her children. Mrs. Nelson has testified that her children love their dad and want to spend time with him. Mrs. Nelson has testified that her children need a close and continuing relationship with their dad. We also know that Mrs. Nelson really believes that her kids are safe with their father because she repeatedly left them alone, unsupervised with him overnight, days at a time, both before she filed for divorce during the summer of 2020, and then again after she filed for divorce. We saw P30, that was the Band-Aid agreement, where Mrs. Nelson agreed to give her husband a standard possession order, period. No alcohol injunction, no anger management class, nothing, just unsupervised time. We also heard Mrs. Nelson make some interesting choices when it came to her children's best interests. We heard Mrs. Nelson testify that she didn't think Bo slapping Aniston on the head in public was in her children's best interest. However, the thing she seemed most bothered by was that it happened in public and not private. Mrs. Nelson told her husband, please don't spank in public. Let's see what's going on first. Ms. Nelson also testified that the medicine Aniston was on during the incident caused her side effects so severe, she began acting out aggressively. Yet she was on the medication for 4 or 5 months before Mrs. Nelson had that changed. Ms. Nelson also admitted that she knew moving Slayton, her son, to Fulshire was not in his best interest. And she knew that because he had adjusted poorly in the past to other moves. Yet she moved him anyway. And when she was asked how she intended to continue that relationship with his dad, said she was going to fly Slayton back and forth. I'd like to talk about parental alienation for a second. Dr. Hartman testified that the way we know parental alienation from regular loyalty conflicts in a divorce is by the pattern of behavior. Mrs. Nelson has a pattern of alienating her children from their fathers. Mrs. Nelson's daughter, Alexis, does not have a relationship with her biological father. The evidence has shown us that Slayton did not have a frequent and continuing relationship with his father when he was young. We heard testimony that Mrs. Nelson said things to Alexis and to Slayton to make them think their fathers did not want to be in their lives. And finally, Mrs. Nelson has taken many actions to alienate her children from their father and stepfather both. Mrs. Nelson tried to falsely establish residence in Amarillo to put greater distance between Bo and his children. Mrs. Nelson enrolled Aniston in Amarillo schools without ever telling Bo or involving him in that decision. Mrs. Nelson enrolled and had both kids attend 5 therapy sessions after moving to Amarillo without ever telling Bo or involving him in that decision. Mrs. Nelson also admitted that she sent sensitive materials and recordings from her marriage to her daughter Alexis after she turned 18 years old, likely alienating Alexis from her stepfather. We saw repeated emails and text messages from Bo asking for information about the kids or to have a conversation about the kids. And Mrs. Nelson simply ignored him or refused to engage. We also saw emails and messages where Mrs. Nelson refused Bo time with the children. Specifically, we have in evidence emails where Bo reaches out after mediation requesting time and is told by Mrs. Nelson he cannot have it per her attorney. Before moving on, I would like to remind the court that under direct examination, Mrs. Nelson stated she thought any alienating behaviors Bo had engaged in were not done on purpose by him, but in response to what was going on. Dr. Harmon testified to how alienated parents can engage in reactionary behaviors that can look like alienation. Mrs. Nelson seems to have confirmed with her testimony that Bo was engaging in reactionary alienation. Dr. Harmon also testified that parental alienation can have very harmful consequences for children, up to and including the increased risk of suicide. I won't belabor that point any further. I know that the court understands and recognizes the harm that can be caused by alienating parents. I would like to remind the court that one of the final things Dr. Harmon pointed out was that the most effective and immediate way, if you're going to have any chance to reverse parental alienation, is through increased contact with the alienated parent. There is only one decision today that does that. There's only one ruling today that gives Bo more time with his kids and does not increase the travel burden on them. And that is relocating them to Fort Bend County. Now, the last thing I'd like to talk about very briefly is just the practicality of it all. Mrs. Nelson testified that she worked online and could do her job from anywhere. Mrs. Nelson testified that she was willing to move back to the Houston area if need be. Mrs. Nelson testified that she had degrees in nursing and psychology and that she had been a registered nurse. And we know that Houston has one of the largest medical industrial complexes in the world. Mrs. Nelson testified that she had willingly moved away from her support system in Amarillo in the past with Bo before, when she moved to Bartlesville, Oklahoma, which was over 400 miles and 6-hour drive. Mrs. Nelson has proven she's capable of making it that far away from her support system in Amarillo. And finally, while Bo being transferred back to Amarillo may theoretically be a possibility, there is no evidence before this court that that is a likely thing to happen. There is evidence before this court that if ordered, Teresa Nelson could start working in Houston tomorrow. It's only one decision in this case that upholds the public policy of this state for close and continuing contact between parents and their children while decreasing the travel burden on the kids. And that's a decision that orders them back to Fort Bend County to live with both of their parents. Thank you, Your Honor.
Thank you, Mr. Adams. Mr. Haston?
Thank you, Your Honor. Judge, if I had known this was going to be a case about moving the children back instead of custody, I think we could have had a lot shorter hearing. All I've heard in this closing argument is all the reasons why these children should be moved back for my client to come back here with them. And not a word in testimony, not one thing that Mr. Nelson said that showed that he had ever been the primary caregiver, much less a player as a caregiver of these children. So the real I guess the first question is who should be the primary joint managing conservator with the right to designate the primary residence? I think the evidence is absolutely indisputable on that. I asked Teresa a litany of questions about all the things she's done with the children, done for the children. I'm sure the court can recall all of that testimony, but basically from the time they wake up in the morning to the time they go to bed at night, and even during the night, she's the one that takes care of everything for these children. Mr. Nelson, although being what he calls an involved parent, is the typical dad who works. Yes, he does things with the family. Most of the pictures that they presented were pictures that were taken by Teresa Nelson on family outings. And do pictures tell 1,000 words? Not always. One thing we do know about pictures is they don't tell what's really going on behind the scene, because everybody plasters a big fake smile on their face for pictures. Nobody ever pouts and looks sad in them because, everybody's going to look at them. Teresa said that when she went to Florida on the trip with Mr. Nelson that he had planned for his own personal vacation, at the last minute invited her to go along. She didn't really want to go, but she felt like she had to. So she went. Things didn't go well, and that's when she decided that this marriage was never going to ever make it. I'm kind of going back a little bit, and one of the things when I first started writing my closing the other day, I started off by saying I'll try to keep this short, and then I wrote probably an hour's worth of closing argument, which I'm trying to cut down, Judge. But the reason I have to talk so much about these things is there's so much data. There is so much information here and Mr. Adams did a great job of painting a picture of a woman who has been self-sacrificial, a phrase that Bo Nelson, one of the few people I've ever met in my life, did not understand the meaning of the phrase self-sacrifice. He'd never heard of it. Asked me what the definition was. I proffered to him that it's actually self-defining self-sacrifice. But Teresa Nelson is a self-sacrificing person, a self-sacrificing spouse, a self-sacrificing parent. And unfortunately, she's a nurse. She's a fixer. She marries broken people because she thinks she can find the good in them and help them to become better. That's what she's guilty of. That's why they had to harp on the fact that she's been married 4 times and Mr. Nelson has only been married 1 time. Well, she's married broken people. And to say that she cut off the other parents from these children. Well, one of the children, as you heard, the daughter, Aniston, was the subject of sexual abuse, and that husband lost his rights to her. Well, I don't think you should encourage a relationship with somebody who's done something like that. She did what she was supposed to do as a parent. She protected her child, and I can't believe they would say the otherwise to that. When you talk about Slayton, they would say that she kept Slayton from his father. Well, we talked a lot about Slayton's father, and Mr. Nelson himself admitted that I think he said he was a jackass and a drunk, and he confronted him on his front doorstep, and he told him he was going to kick his ass and that he didn't like the man. Slayton's dad's not a good guy, but Teresa Nelson has worked with him over the years, and they did settle all issues when she had to move the first time because Bo Nelson got a transfer. She wouldn't have had to fight with her ex-husband, and she didn't keep her child from her ex-husband. Bo Nelson got a transfer, and she had to go with her husband, Judge. He said, maybe I mistook it, but he made it sound like Slayton's dad was in Amarillo, but Slayton's dad was in Tulsa, Oklahoma. The parties were in Amarillo. So it was very difficult for him to exercise his periods of access and possession, but it wasn't because of Teresa Nelson. It's very hard dealing with an alcoholic and a pushy, abusive person, as we've seen throughout the testimony in this case, Your Honor. And that's what one of the things we were talking about public policy in section 153.001. And the key phrase in that is we want to assure frequent and continuing contact with a parent who has acted in the best interest of the children. This man has not acted in the best interest of his children. And let's go back to August of 2019. And let's go to Mr. Nelson's own timeline, in which he falsely testified that he moved to Fort Bend County because he got a promotion and a raise. Well, that's a great reason. And Teresa went along with him. But through cross-examination, he finally admitted that it wasn't because of that. It was because of, once again, being written up at work and getting in trouble, because in this case, he had said or done, it was a little bit cloudy, something to or about a young female intern. In his testimony, once again, he didn't take responsibility for anything that happened with that. He said it was because of something she didn't understand. Well, that's really interesting if she didn't understand it when he was the one that was being asked to move because of his behavior. So he lied to the court in his own testimony. And really, that's the root of all of what we're hearing today. Best interest of the children. This man, not in the best interest of his family, uprooted them from the one hub, the one place that they had always come back to and they had spent substantial periods of time in, which was Amarillo, where Teresa Nelson's parents lived, who were very involved with the family and with the children, and her extended family, her aunts and uncles and relatives, not to mention her own friends that she had grown up with and her extended friendships there. Not to mention the children that these children had attended, at least Aniston had attended some school with, and Slayton had attended school with. These kids got to go back to those people. They got to go back to those friends. But when they got pulled away from there, they got pulled away from there because of Bo Nelson's bad actions. Now, why did my client, as they said, allow her to go? And I can't believe they would attack her for allowing him to go. Everything was allowing Bo to do this bad thing or allowing Bo to do that bad thing. She allowed Bo to have multiple affairs. She didn't allow him. She was trapped, Your Honor, like every other abused woman is. She was trapped. What could she do? When she didn't want to move to Houston, he threatened her to make her penniless. He threatened to take her children away from her. Guess what we're having a custody hearing for right now? Him to take her children away from her. He told her he would leave her penniless and living in a shack and he'd spend everything he had to make sure that happened. Okay, so what happened after that? Well, then he did his next thing, which is when he realized that wouldn't work, he came back and does what he always does, which was love bomb her. I love you. We're going to make it work. I'm going to buy a house. Everything's going to be great. Everything will be different. And so finally he worked on her and he worked on her. And when she wrote him that letter, she really thought that he was going to make the right decision. That's why she wrote him the letter. She wanted to give him make him feel empowered to make the right decision. And he did make the right decision. He woke up the next morning and he told her that he had thought about her words. He had thought about everything they had talked about and he was not going to move them. But what did Bo Nelson do the next day? He didn't call her. He didn't say we need to discuss this some more. He said in a text message, we're moving to Houston. That's how much he values this lady. That's how much he values acting in the best interest of his children. He could have just as easily stayed there. There was no testimony saying that he was going to be dismissed from his job to stay in Amarillo. He moved to Houston to get away from the heat of that situation, which was good for Bo Nelson, not for Teresa and not for his kids, but good for Bo. Teresa Nelson, and let's talk about something else that's really important. We talked about character a little bit during some of our conversations during the testimony. Character is really, really important because the character a person has, that flows out into everything they do. Mr. Nelson's character he's a repeated serial cheater, Your Honor. He's a person who cares so little about his wife that he goes and has affairs with other women. He gets oral sex in the parking lot. Then later on, after having these affairs with women, he tells his wife, you're fat, and he compares her, belittles her, and compares her to the people that he's had sex with in violation of his marital vows. What kind of character is that? I asked him about telling a little truth to cover a big lie or telling a little truth to cover a big truth. And he admitted in his interrogatories and his testimony that, oh, this woman, it was just sexual texting, or this woman, it was just we made out and I slept at her house, but we didn't have sex. Well, we're all adults here, Your Honor, and I think you know how people really are. And I think the testimony and the character of this man tells us the real story behind that. Now, physical abuse, wow. I don't recall Teresa saying that she made Bo bleed. I remember Bo going on about how much he bled and how he didn't go seek medical attention and how he didn't put into evidence a police report and how my client was not arrested. So whatever happened in that one particular incident, if he got scratched, I'm not sure how that squares up against chasing your wife around a house 18 days after she's just had major abdominal surgery for a prolapsed vaginal wall and rectal wall, and having to have a bladder sling put in and having to have surgeons go in through both orifices plus 4 other locations in your abdomen to try to put you back together after bleeding like a stuck pig, in her own words, for 3 months. And what about that tape that we heard that in? He was going on about why she wouldn't work and why she sleeps all the time and why she doesn't take care of the family and do her job. And she says, Bo, I've been bleeding like a stuck pig for 3 months. What was his caring, loving answer? I don't give a shit, Teresa. That speaks mounds about the character of a person. How about the fact that he confronted her over her 70 control? He got mad at her for paying $75 for her nursing license renewal. Boy, that's something terrible. That's something to yell, suck my dick to your wife for. And luckily we had one audio tape, because when he chased her around and grabbed her around the waist and yanked her phone, actually his own testimony was ripped her phone out of her hands, but somehow didn't injure her in his own words. He took the phone and deleted all of the audio recordings that she had on her phone so that she wouldn't have evidence about what an abusive person this man is. But luckily, she had one saved. Well, she got cross-examined on that as if she was a bad mom for sending her 21-year-old daughter a copy of that one audio tape. I don't blame her. Thank goodness she did. He's the one that destroyed evidence. And I don't see how we can reward somebody for cheating, stealing, lying, and abusing. Now, is she to blame for this? Well, I mean, I don't know. Some people can't help it. They find people like this, and they want to believe the best of them. They want to believe that they want to see the best in people, and that's what this lady did, and that's what she got hammered for. She got hammered on cross-examination for this, Judge, for letting this man abuse her, and then him coming back and talking her into staying with him. And then it happens again and again and again. And she keeps coming back. She didn't do it this time, Your Honor. Did she fudge him a little bit on going back to Amarillo? Yeah. Why wouldn't she? This is the same man that when she didn't show up at the right place just when he said she should, and she was a few minutes late on returning his text, he turned around and drove with the children all the way back to Fulshire, making her follow him in July, I believe it was July of 2020, July 19th, I think, all the way back to Fulshire because he said he wasn't going to give the kids back. And then she had to stay there all the way through until July 28th with him trying his hardest to once again drag her back into the fold. Because he realized he had really done it this time. He realized that she was not going to stay. He realized he was really losing her this time. And he did. And what did she do? Did she want to get the children back to where their support system was? Did she necessarily want to get them away from their dad? She didn't want to necessarily get them away from their dad, but she needed to be somewhere where she could have love and support. She didn't have support from her husband. This guy in 2019 was gone 22% of the time. A lot of that for his fishing and hunting trips. You heard in the testimony how upset he was that he hadn't been out hunting and fishing in over 3 months. Well, and then somehow it's wrong of her to say, well, I think he said, well, you do you and I'll do me. This is the same man that in that argument, Judge, he cared so much about whether his kids sit in the car or not. He was the one that told her she should take him with her to go pick up and drop off Slayton to his dad. Well, that's 3 hours each way. That's 6 hours where he didn't want to be bothered with his kids. He wanted her to take them with her. He wanted her to take them with her. I think I got that one. Because he didn't want to be bothered. You heard her testimony that, yeah, he does stuff with the kids, but did we ever hear him say he did stuff that the kids like to do with the kids? No, he likes to hunt. They go hunt. He likes to fish. They go fish. He wants to change a tire. They learn how to change a tire. 5-year-old. Or is it oil change? I can't remember which. But he taught them that. I'm sure they're going to remember that life skill. When did we hear him say he gets down on the floor and plays with the kids with their fire engines or their dolls? Not one word about it. He's not an involved father. He's the kind of father which is, you want to spend time with me? You do it Bo wants. Both way or the highway. We heard that several times. In listening to the tape, we talk about alienating behavior. Wow. I think it's really interesting that they called Dr. Harmon. She seemed like a very nice lady, a very well-studied and educated person. But she also recognized Dr. Richard Warshak as being probably more preeminent than her. And she agreed that we have to draw a line between parental alienation and alienating behavior. She agreed that if a child is not rejecting a parent or refusing to see a parent, then there is no parental alienation. Just because a party does some things that would be an alienating behavior does not create parental alienation. And nobody, my client included, is saying that these children are alienated. The only audio that we have is about children not wanting to see another parent or yelling at a parent is, for some, inexplicably, they put this audio in of the handover of Aniston. Well, my client is not going to sit here and try to twist that into parental alienation or alienating behavior. I will say, I wonder what went on in that car for 3.5 hours before he got to Burleson that to make his daughter react in that way when mom came to pick her up. But mom handled it well, and she settled down and she was fine. That's at the very worst case, that is just separation anxiety that could easily happen with any child at the age of 7. But was he using alienating behavior? I don't know. Other evidence in the case in the hearing points to that. One of the most telling ones, which doesn't seem to bother him at all, is that, and I think it would be appalling to just about anybody to hear this, is that he took his children through the house and removed all pictures with mom. Now, what kind of if that's not alienating behavior, I don't know what it is. What kind of message do you send to a child when you say, we are erasing your mom from this house? And while we're talking about best interest of children and acting in the best interest of the children, a month after I don't remember when it was, but a month after she was back up there, he was already dating this woman named Katie. His own testimony is that at least half of the periods of possession he's had throughout this case, Katie has been there at some point around his kids, but he didn't tell her that it was his girlfriend. Well, that makes it okay somehow. Judge, this guy's level of ability to look into himself, his level of introspection as a parent and a human being is level 0. I have never seen somebody with such a low level of empathy. And we talked about narcissism. I'm not a doctor. And I know Mr. Adams will come back and say, Mr. Haston admitted he's not a doctor. No, but I'm a human being that's 55 years old. And I've seen narcissists, and I've seen people call people narcissists, and I've said, that's not a narcissist. That person's a little full of themselves. But Judge, if I've ever seen a narcissist, that's that man sitting right there in front of you today. I've never seen somebody, when asked, what are all the things that make your wife a good primary joint managing conservator or primary parent of the children, doesn't give an answer to the interrogatory. Finally, Lori Kern was able to squeeze out of him about 3 words that he could say good about Teresa Nelson as a parent. She loves them, she takes care of them, and one other thing. That was the only thing I've heard him say positive about her throughout this whole case. But now Mr. Adams wants to say, well, look how easy it would be for them to come back, Judge. Well, it might be easy for them to come back. And yeah, you know what? This is that key phrase, self-sacrifice. We're not going to put this lady up on the stand and make her lie and say, oh no, I can't move somewhere else with this job. She can. It's online. She would like to have something better, but it's something she can do that pays more money, which might make her stay in place if she can get back to being an RN. Yes, she could move back down here, Judge, but it's not in the best interest of the children. That's not the issue. Mr. Nelson created a situation where he put the children in a bad position, and Mrs. Nelson saw an opportunity to correct that. And on top of that, Mr. Nelson's own testimony was, again, it's such a low level of introspection that it never crossed his mind to even bother to call his boss or somebody up in Amarillo or talk to the people here and look into a transfer. Now, he had done it before. He had done it before in the past when he had gotten in trouble once again for cheating on his wife, and she went back to Amarillo. And so in order to follow her, because he still wanted her then, he applied for a transfer and he got that. But he hasn't even inquired about that in this case. What does that say? What that says is this is a competition. This is a fight. This is a fight for these children. These children are a battleground. I'm going to win. I'm going to punish her, and I'm going to make these children come back, and I don't care how much money I'm going to have to spend to do it. That's what this case is about. They can sit here and continue to say things that in a way are really, really abusive to this lady. To say that she allowed things to happen, what else could she do? Divorce him, I guess. She could have divorced him the first time he cheated, the second, third, fifth, sixth. Well, yeah, but she's a person who has been psychologically and physically abused. By the way, he admits that he jumped out at her on occasions to scare her and even did a little jump like that at the camera. And he did that to scare her. And he once did it when she was pregnant with one of their children and holding a boiling pot of water. He admits he's punched holes in walls, he's thrown plates, he's thrown pans at her. This is a person who can't control his violence. It's a person whose life is all about himself. He has no, here's another thing. Remember that telephone call where he's talking to the kids? And at the very end, I almost stopped playing it because the part I wanted you to hear was at the beginning. But at the end, he was talking to Aniston. And Aniston starts to go on about her little doll. And it's a sweet little story. She's talking about her dress and how pretty she looks. And I thought for a second, man, maybe this is it. We're going to see him be a human being. And instead, she gets finished talking about her doll and how pretty she is. And she wants to show the baby doll to him. What does he say to that? Nothing. He tells her how much he misses her and he needs to see her. He completely misses the cue that any good parent would see, which is to stop and be self-reflective and say, oh, tell me about her, sweetheart. He didn't do anything like that, Judge. There are plenty of ways that he can see his kids and be involved in his kids. Number one, he could try to move back to Amarillo. They have a big operation up there. This isn't the only place, but this is the place where Bo says it's good for him to be. He could easily sell this house at the seller's market. He could understand, hey, wow, if we're going to be divorced and I make $150,000 a year and Teresa only makes $37,000 and we're spending the entire community state on ridiculous attorney's fees that are unnecessary, then maybe it would be better for her to be able to be there with the kids. Maybe that would be better for her to be able to parent in a world where she can have some financial and family support. But that never crossed his mind because it's win-win-win. Bo Nelson has to win, and Bo Nelson's never wrong. Once again, he wasn't wrong when he got that job and got the horrible reviews from all the people that he had been promoted above. That wasn't his fault. He was a young, smart, go-getting 31-year-old manager, and they all resented him because they were old, and they all resented him and held it against him, and that was all their fault. Not his fault, their fault. Nothing's ever his fault. I'm going to guess that it's probably not his fault that he cheated on his wife and had sex with multiple women. I'm going to guess that it's her fault that he had to hit her during their marriage. And it's also her fault that even when she's talking to him pretty calmly, he has to tell her to suck his dick and fuck you, Teresa, and I don't give a shit. I mean, everything about this man says that you should probably let her move across the United States, Your Honor. You didn't hear anything from him about how they were doing in school here because they were only in school physically here for 2.5 months. They were only in Texas for 3.5 months. So no, did they establish any kind of life here, relationships with other people, anybody here? No, no family members, no neighbors, no school friends, nothing. Everything they have is in Amarillo, except for Bo. And Bo Nelson is the person that could probably make that change effectuated. We didn't hear anything about, I mean, I don't know. We heard Teresa talk about how hard it was to move her son Slayton down there. And after she saw what he went through, her testimony was, even if the judge orders the children to be moved back to Fort Bend, I'm going to leave Slayton up there. That's a self-sacrificing mother. Why? Because she's not going to make him go through high school, having to jump back into another high school again. She's going to let him finish out his high school career with his friends. That's what's important to a teenager. We all know that. And then if she has to move down here, she's going to do the long trek back up there on dad's weekends to see her kid and spend time with her kid. Is that something Bo Nelson would do? No. Bo Nelson says that if she gets to stay there, he won't meet her halfway. He'll let her leave a little later now, finally, after about 6 months and 8 absences, putting her almost in the truancy court. So the kids can come now to see me a little later at 7, but we're still going to demand that Teresa do all the driving. Boy, that's a self-sacrificing person. That is somebody that really, really cares. I think the evidence is really, really clear, Your Honor. I'm surprised this was presented to you as a custody case from the other side, because I didn't hear one thing in closing, or I didn't hear one thing in the evidence that supported Mr. Nelson having the right to designate the primary residence. All this is could have been real quick, make her move back, and she would have had to explain to you all the reasons why that shouldn't happen. But we've done it the long way, even having to introduce about 8 pieces of evidence in the financial evidence that ended up not being objected to after they were objected to. And we basically tried a final case on custody today and during this case. And I appreciate your time, Judge. I know how busy this court is, and I know that you've given it the weight and gravity that it deserves. We're asking the court to rule as set out in our request, summary of requested relief, but specifically that Ms. Nelson get to be the primary joint managing conservator and establish residence in Randall County. We've agreed that maximum child support, I think we said, was $2,300, I think was the number. Whatever that stipulation was, I would ask that Mr. Nelson continue to maintain the health insurance on both Ms. Nelson and the children. And that we would like an alcohol injunction against him, because she did testify that he does drink quite a bit. I understand it wasn't the strongest evidence. Leave that in your lap. Honestly, I've never tried a case like this, Your Honor. I've never tried a case one time asking that a parent be allowed to move or live somewhere else. This is the first time I've done it. First time I've ever found that the facts supported it, and I ask you to find so.
Thank you, Mr. Hassan. Ms. Kern?
Yes, Judge. I do have one question for the court, Judge, and that is, are you requesting that as the amicus that I make a more formal closing statement, or is the court simply requesting my recommendations?
You can just, however you proceed, however you want to do it, Ms. Kern, it's fine with me. I would just say, give me a summation and what your recommendations are.
Certainly, Judge. And I would like to state for the record, of course, that there is no doubt in my mind as the amicus that both of these folks love these kids. They both want what's best for their kids. We just have very, very different perspectives here, Judge, as to what that best interest is. And obviously, especially when we have children that are this age, when the children are with mom, they miss dad. When the children are with dad, they miss mom. I have a lot of concerns in this case. Dad does not have a history of being the primary caretaker. He's traveled extensively for work. I think it's been pretty undisputed over the days that we've had of hearing here that mom has been the primary caretaker for the children. That's what's in the comfort zone of what these children know, what these children are accustomed to, and what's in their best interest in terms of their day-to-day life, their activity, their care. I have a lot of concerns that while Mr. Adams said he wasn't suggesting that a woman deserves to be treated poorly by a partner, that's sort of exactly what the argument is that the position is that she's made her bed, she has to lie in it. And I'm very concerned about the exposure of these children to further conflict, further toxicity, further abuse, further escalation of those types of things. As the amicus judge, I am requesting that the court order these folks to use our family wizard for all of their communications to reduce conflict, to reduce damaging communications between the parties. I am requesting that the court, we established at the last hearing session or session just prior to that Dr. Bevan was going to be doing a custody evaluation in this case. I don't anticipate that Dr. Bevan is going to be finished with that custody evaluation anytime over the next 3 to 4 months. Given that we are already halfway through March, I would request that the court make specific provisions for summer of 2020. Presuming that Dr. Bevan's report isn't going to be completed by that point, I don't think that either parent should have weeks and weeks of unfettered access to the children. I think that we need to try to figure out a way to divide up the summer, and I would request that the court do that. I would also request that the court address the electronic or FaceTime communications. Those seem to be a big source of conflict here. Right now, I think under the handwritten Band-Aid orders that were put into place, there's a provision in there that there's a 15-minute minimum imposed on the FaceTime communications, and I would ask the court to eliminate that 15-minute minimum and just keep it the way we generally do, Judge, with reasonable communication. I don't think that we need to put anyone in a situation where either parent has the opportunity to sit there with a stopwatch to say whether or not a minimum or maximum amount of time has passed. I think that it increases conflict and increases pressure on the children. And I think that because of the conflict and pressure on the children, every other day, FaceTime or electronic communications is probably sufficient as opposed to every single day. In addition to the injunctions that are already in place, just the standard temporary mutual injunctions, we also ask the court to consider the 12-hour alcohol injunction. I have no issue with that injunction being neutral as to both parties. I'm also going to request that the court put in place the additional, as we sort of refer to them informally, the amicus injunctions that we use a lot in these types of cases, where injunctions about using children as a messenger, leaving documents or showing documents related to the case to a child, engaging in discussions with a child related to choice of conservator, making disparaging remarks on social media. If the court would order those, I'm happy to, as the amicus, certainly circulate a copy of those injunctions to both attorneys and request that the court implement those. I also would request that at the time of the entry for temporary orders of this case, we also have that date as our entry of the order appointing Dr. Bevan and setting out the specifics of Dr. Bevan's custody evaluation in this case, so that we can get that rolling as quickly as possible and have those parameters in place for Dr. Bevan to begin work as fast as possible. Those are my recommendations and my position as the amicus judge. And if the court has any questions, I'm happy to answer those however the court needs to.
All right, thank you. You're kind of cutting out on us. You're having some microphone issues there. At the end, did you say you wanted me to that there was an order for Dr. Bevan that had been e-filed, or you're just saying you want an entry date for that order? I didn't hear that part.
I apologize, Judge. There has not yet been a circulation of that order, so I would request that at the time of the entry of the temporary orders in this matter, we set that for entry as well, so that we can have an order circulated, drafted, and we can get the court signature on that.
All right, thank you.
Thank you, Judge.
All right. I want to first tell Mr. and Ms. Nelson that it's a pleasure for a judge when I have lawyers that are ultra prepared, that know the facts of their case inside and out, that know how to present a case and that can do it professionally. And I can tell both Mr. Nelson and Mrs. Nelson, y'all were very well represented in this case. Both these lawyers did an excellent job, and the amicus has done a very good job. But these are difficult cases. I think we can all agree on that. These geographic relocation cases are difficult on the court. It's difficult on the parents. It's difficult on the parties. And my knee-jerk reaction as a judge and as a lawyer was typically mom and dad need to live close to each other. And that's the public policy in the state of Texas. And that's something that I don't take lightly as a judge. But I do think this is an exceptional case for a lot of reasons. I'm not going to go into all that today. There's no need for me to do that. But my ruling is going to be a little bit different than what I typically do on these kinds of cases. Entry of this order will be March the 26th at 9 a.m. We will also make entry of the custody evaluator order on March the 26th as well. Mr. Adams, if you'll draft the order for custody evaluator, if that order hadn't been prepared yet. Mr. Hassan, if you'll draft the temporary orders, we'll split up the work associated with the drafting of the orders. The court finds that all the following temporary orders are in the children's best interest. Bo and Teresa Nelson are appointed temporary joint managing conservators of the minor children. Ms. Nelson's granted the exclusive right to determine the residence of the children within Randall County, Texas, or any county contiguous to Randall County, Texas, as well as Fort Bend County, Texas, and any county contiguous to Fort Bend County, Texas. Mother is awarded the exclusive right to receive and disperse child support payments. Mother is awarded the exclusive right, after prior consultation with dad, to make educational decisions. That includes deciding the school in which the children will be enrolled. Mother is awarded the exclusive right, after prior consultation with father, to make invasive medical decisions. Mother and father are each awarded the independent right, after prior consultation with the other parent conservator, to consent to psychological and psychiatric treatment of the children. The marriage or enlistment of the children requires the joint agreement of both parents. All of the rights will be shared independently between mother and father. Each party is awarded the independent right to apply for a passport for the children. Mother is awarded the exclusive right to maintain possession of the passports, subject to the standard notice and delivery provisions per the Texas Family Practice Manual. Per the Amicus request, I will order the parties to communicate through either talking parents or our family wizard. We'll do talking parents because it's free. The parents are ordered to communicate through Talking Parents app, except in the event of an emergency. If the parents need to communicate about an emergency dealing with these children, they can communicate with each other directly. But short of that, the communication shall be through Talking Parents. Father is awarded a standard possession order for a parent over 100 miles. He may make an election whether or not he wants to do first, third, and fifth weekends or one weekend per month. Father's awarded that standard possession order. The court's not going to limit the 42-day summer access. I'm taking into consideration the fact that the dad went an extended period of time without seeing his children. I'm not going to break up his summer possession. I understand the reason why the Amicus and Mr. Haston have requested that, but that request is denied. He may exercise the summer access however he sees fit. Other than the days where there is a pickup and drop off, the parent not in possession will have FaceTime access with the children between the hours of 6 and 7 p.m. If the children are not available at the time of the call, the parent in possession shall assist the child or the children in returning the call as soon as that child becomes available. That FaceTime access is to be reasonable access. I'm not putting a minimum limitation on it, but mom and dad, hear me out. If one parent makes a call and they get a 1-minute access with the children, or it becomes a pattern that there's the phone calls, the FaceTime calls are minimal, then I'll further restrict this and further, put conditions on it. But my hope is that you're both good parents and you understand that the children want to have a healthy relationship with both these parents. And I think it's critical that dad have FaceTime access since these children are living so far away from him. And so I want meaningful, reasonable access for dad with these children. And mom, that's true for you too. When they're going to be away from you for 42 days in the summer, you're going to want the same benefit with those children. So just both of you understand that the court wants that FaceTime access, but I'm not putting any other limitations on it than what that it's to be reasonable access. Pick up and drop off. It's going to be as follows. If it'll be on the Fridays of dad's visitations at 6 p.m. and the return time will be on Sundays at 4 p.m. Pickup and drop off locations are going to be the Chick-fil-A located at 901 South 7th Street in Waco, Texas. So That'll be for Friday and Sunday. That should take care of the school issue. Mom, you're doing more driving than dad. That's intentional on the court's part. But I think this will accommodate making sure Aniston gets to do her school on Friday. Child support. Pursuant to section 154.123, court finds evidence that rebuts the presumption that guideline support is in the best interest of these children, and that it justifies a variance from the guidelines because of the cost of travel associated with father exercising his periods of possession. The court finds that the child support guidelines should be $2,300 per month, but I'm ordering a variance of that support. Father is ordered to pay child support in the sum of $1,800 per month beginning April the 1st of 2021 and continuing on the 1st of each month thereafter until further order of the court. That child support shall be through an income withholding order. Mr. Nelson, what that amount of money does is it gives you about one visit per month that you could fly to Amarillo so the kids aren't in a car. You can get a hotel in Amarillo. It's not going to cover all those costs, but it's going to cover the majority of it. And that's my intent, is that you'll exercise that privilege and you'll use that money that you're saving and not paying child support to exercise a period of visitation in Amarillo. If you choose to do that, then more than likely this court may consider, if this is the ruling on a final, that we need to continue that offset. If you choose that you're not going to do that, that's okay. I'm not forcing that on you, but you need to understand that this variance is probably going to go away because the purpose of the variance is to allow you access one weekend, which would keep the kids from being in the car for 10 hours, allow you and mom not to have to travel or allow mom not to have to drive, and give you a cut off your child support obligation. Father is ordered to continue to provide health insurance on and dental insurance on the wife and on the children the subject of this suit. Any uninsured medical expenses are to be split 50% by mom and 50% by dad. There are standard mutual injunctions already in place, but I want these injunctions included in the temporary orders, Mr. Haston, so that the parties can look at one order and know what their rights and obligations are. So if you'll add those standard injunctions to this temporary order.
Yes, sir.
The court will grant the request for from the amicus to add the additional injunctions that she's requesting, except for the alcohol provision. The request for an alcohol injunction is denied at this time. The court may reconsider that, Mr. Nelson, on a final in the event that I get additional evidence that it's a problem. But I'm going to trust that you're going to monitor your drinking when the children are with you, and I'm going to trust that you can do that. So I'm not putting an alcohol injunction on either party at this time. I am, however, sua sponte ordering a paramour clause or morality clause. That means that Mr. Nelson and Ms. Nelson, you're not to have boyfriends or girlfriends around the children between 8 p.m. and 8 a.m. on any of your periods of possession. So I'm not going to tell you to keep boyfriends or girlfriends away during the day, although I don't think that's wise to do right now. These kids are going through enough with their parents splitting up. But that being said, the prohibition will be 8 p.m. to 8 a.m. The court is awarding interim attorney's fees of $40,000 awarded to Mr. Haston. That's to be paid from one of husband's accounts. It can either be the 401k, husband's IRA, the stock account, and that needs to be done by March 31st, 5 p.m. I know that's not how much is necessarily anticipated that this case is going to cost, but I feel like that's sufficient to get Mr. Hasson up, and then it'll give mom time to get her accounts in her name, because more than likely, ma'am, you're going to be ordered to pay your attorney's fees going forward after this interim award. But I'm not saying that for sure. I'm just telling you that's kind of how I feel right now. Temporary spousal support is denied at this time. Fathers awarded exclusive use of the property located at 30419 Garden Glen Court in Fulshear, Texas. as well as the furniture, furnishings, and personal property in that residence. Father is ordered to pay the monthly mortgage, upkeep, and utilities on that residence. Father is awarded the exclusive use of the vehicle in his possession and to pay any debt associated with that vehicle. Mother is awarded the exclusive use of her current residence, and she's to pay any bills associated with her residence. And mother is awarded the exclusive use of the vehicle that she's currently driving. And is there a debt on mom's vehicle? I never heard that.
No, sir.
Okay, so I don't have to worry about that. That completes the order of this court. Mr. and Ms. Nelson, I wish you two the best. I do hope that the two of you can take this ruling, even though, Mr. Nelson, I know you're not happy with it, and I get that. But I hope the two of you can take a day or two to think and realize how much money you two are spending on attorney's fees. And they're very good lawyers, and they'll continue to fight hard and aggressive for you. But my hope is that you can put those funds to better use for your children, and that y'all can come up with some way to try to get this case resolved, because you're in very good hands with the lawyers. But I hope that that can happen for y'all, because I think that's probably in your children's best interest. That completes the ruling of this court. Thank you all.
Judge, may I ask a couple of questions for clarification?
May.
Thank you. Number one, on the FaceTime, we've had some issues with the phone calls happening at the very last minute. I know the shoe was on her foot to make her initiate the phone call, and Mr. Nelson was supposed to make a return phone call. So I guess my question is, do the calls have to take place and end between 6 and 7, or can Mr. Nelson call at 6:59 and then expect to have a reasonable period after that?
What time do the children normally go to bed on a school night?
By 9 o'clock.
I think as long as the call is made between 6 and 7, that there should be reasonable access. So if it's made at 6:59, obviously you have to understand that the kids are going to be in a routine. And if the kids normally eat at 7:15, well, calling at 7 is probably not the best time. But as long as the call is made between 6 and 7, there'll be reasonable access.
That's right. Judge, I don't remember if there was testimony on this, and I might ask Mr. Nelson if he can clarify. Do the parties have an HSA?
Yes, we do.
So to the extent there's an HSA, Judge, I would ask that you consider that and have the parties use that first before they start paying 50-50 each.
Can I respond?
Absolutely. I didn't hear, that probably is on the wage withholding, the paycheck stub, and just didn't catch that. But the HSA does need to be utilized. I'm assuming that that's being funded, Mr. Nelson?
Your Honor.
Paycheck?
Yes.
Currently?
I'll respond.
You may.
Your Honor, so I would prefer that Teresa stop using that just due to tax purposes. Otherwise, we're going to have to file taxes together in 2021. I think that she's used a significant amount of it as we saw for her personal. I agree that the kids should be utilized under that. But as far as her personal chiropractic work and all that stuff, I would recommend that we stop utilizing that.
May I respond, Judge?
I think that you may.
I'm sorry, but this is a community asset that's been built for the community estate, and either party or the children should be able to access that.
There's tax ramifications.
Hold on. Based on Nelson, I'm about to rule in your favor, so it's best just to be quiet now. We're going to utilize the HSA account exclusively for the children. If there's an expense that we need to get into as far as mom's uninsured, I understand it's a community asset, Mr. Haston, but I don't know how much is being funded in there because I didn't get a whole lot of evidence on it. We're going to utilize the HSA account to pay the kids' uninsured medical expenses to the extent that there's money there. If there's an expense that goes above and beyond the HSA balance, then each parent's ordered to pay 50% of it.
Thank you, Judge. And I have just one final thing. I believe we didn't, because this was getting so long, I believe my client still has some personal belongings like clothing and other personal belongings in the home. I don't know how to address that other than to ask that she be allowed to, I guess, on one of her, maybe have a trip down here where she could come in the home and get her personal belongings out of the home.
I would recommend the lawyers agree to that. I mean, that's not part of my ruling because I didn't get that evidence, probably because, you know, we're here late in the day. But obviously, Mr. Nelson, I want Ms. Nelson to have her clothing. I want the kids to have, you know, if there's stuff that the kids need in their primary home, I would prefer that they have that there. I'm not saying you need to give everything up for the kids, but hopefully the lawyers can work through that. In the event you can't, just earmark whatever you can agree to, and the lawyers can come back, and hopefully we can have like a 15-minute or 20-minute hearing just on those issues. But my hope is y'all can work that stuff out. But
Yes, sir.
absolutely, mom should have in her personal belongings and some of the kids' personal belongings as well.
Thank you, Judge. I appreciate you taking the time.